going to talk a little bit about this new project that I've been working on called Queer Judgments. We've just got the edited collection out, published by Counter Press. It's available to order, and you can order it on a pay what you feel basis as an ebook. So it's free should you wish to get it online on the Counter Press website. So today I'll be talking a little bit about this movement around what we call critical judgment writing. So reimagining legal judgments from different critical perspectives. So queer is what I will focus on today, but it sits within a broader lineage of feminist, indigenous, earth, children's judgments projects as well. And there will be more to come in that space. I'll also talk a little bit about sort of doing and being queer in law and sort of how queer arrives in sort of legal spaces and kind of navigating the tensions that that word, idea, feeling inspires amongst those of us who work in legal spaces and institutions. And then I'll talk quite specifically about what I contributed to this collection, which was a rereading of a very famous, for the wrong reasons, Australian or New South Wales criminal law case about what used to be called the homosexual advanced offence and the ideas of provocation that used to sit behind that. So, queer judgments. So this actually collection was born when I was here in Sydney during COVID, fortunately locked down here with family and with friends. And it started as a conversation amongst a number of colleagues and friends of mine based in the UK and abroad who had, been thinking about this for a little while now. So we had sort of talked about, the teaching of gender and sexuality in law, which used to be taught here at Sydney in the law school, currently is not, although there are many people doing work in that space. There is a course over at UNSW, UTS, but this kind of thinking around the relationship between gender, sexuality and the law has really been percolating and kind of developing for quite a few decades now. And so many of you in this room are probably familiar with queer theory, feminist theory, some of the key debates, and the ways in which kind of those particular intellectual projects were both a part of social movements, but also a part of kind of individual academics and scholars working in different institutions and trying to kind of bridge that kind of activist academic gap. And so similarly in the kind of legal space, you had a lot of feminist, queer, decolonial, critical race scholars kind of working in what would then be described as critical legal studies. So in the 80s, particularly in the context of the US, the development of critical legal studies, which was very much bringing critical theory into law, rethinking the politics of law, making explicit a lot of the ways in which the legal system marginalizes particular groups of people, so, indigenous people, racialized people, disabled people, women, queer people, trans people, and so on. And so that spurned, if you like, this movement around critical legal thinking and the various, tracks of feminist, queer, and decolonial thinking that led to. So, unsurprisingly, if you do legal studies in many places, you'll be taught some of these perspectives, maybe not as a standalone unit, but they'll be integrated into some of the core units that you might study in a law school. There's also lots of conferences and research that has taken place, and you can find lots and lots of academic papers around, critical legal studies. What's been a bit more of a recent development is the idea of using critical legal studies or critical legal theory as a form of practice, if you like. So rather than merely critiquing the law or using these critical tools to analyze a legal problem and identify the kind of norms at play, the ways in which they marginalize particular communities, it's been to kind of almost put academics, and this has been an academic project, an activist project in some ways when it started, to assume the position of someone in a position of power, in this case the judge, and to kind of act in that institutional environment. And so one of the first critical judgments projects was the Feminist Judgments Project, which began in the UK, which was very focused on England and Wales. And academics involved, Rosemary Hunter, Erica Rackley, and Claire McGlynn, were very interested in basically taking cases from England and Wales, And we're writing them with a very particular convention in mind. That is, they wanted to write feminist judgments, but feminist judgments that fit within the constraints of the English legal system. And what do I mean by that? So they wanted to, be faithful to doctrine, to precedent, obviously coming from a common law jurisdiction, using the previous case law in order to reason, anew in new factual scenarios. And they also wanted to follow the similar conventions of judges, right? How they write, how they structure a judgment. And essentially, and it's described in the introduction to their volume, they wanted to write something that a Court of Appeal judge or a Supreme Court judge could pick up and read and go, okay, I might disagree, but I could have written that, or I can see how that fits with the kind of legal norms of the institution. That spurred a whole range of feminist judgments projects. So we've got feminist international law, international criminal law, we've seen African feminist judgments, Australian feminist judgments, we've got and they all obviously kind of take their own intellectual and cultural traditions in that. We've also seen the Indigenous Judgments Project, which was just released a year ago or 2 years ago, here in this context, reimagining Indigenous law and sovereignty in relation to the common law and the English legal system. We've also seen children's judgments. We've also seen earth law judgments, so thinking of nature and the environment and centralizing that in kind of conversations. And so in this tradition, we sort of kind of arrived going, okay, what would it mean to do something queer? What does a queer judgment even mean, right? So I think we can start is, what does queer even mean, in that very broad way? For those of you familiar with some of the kind of intellectual debates in queer theory, you'll know that, what is the object of queer studies has been the subject of, papers for decades about, is it, are we looking at sex? Are we looking at, particular types of sex? What does it mean to reimagine or bring queer theory into thinking around militarization or borders or sovereignty? There have been debates between, Lee Edelman and Lauren Ballant and Jose Munoz about, do we hew to a kind of anti-social, unmaking of the world, or do we invest in certain forms of sociality and certain forms of world building because we think that's important for our collective progress as kind of marginalized people. So obviously I'm not going to go into that detail. There's a lot of really interesting and good work that I would recommend kind of reading in that space. But it was something we had to confront because, of course, if you ask different people what they mean by queer, even as an analytic concept, not just an expression of identity, but as an analytic concept, you'll get very different ideas. Even if you ask them sort of what would it mean to do a queer analysis, does a queer analysis require you to talk about queer people or trans people? Or could you do a queer analysis of the river or the ocean? Could you do a queer analysis of cultural heritage? And so when we put this collection together, we wanted to play with the idea of queer in all its kind of valences. And we didn't want to be overly prescriptive about what we meant by queer. We wanted to give people the opportunity to use queer in ways that, felt relevant to the kind of audiences and jurisdictions they were responding to. And so that was really important to us because, of course, this is quite an international project. It's one of the things we're really proud about. We do have some, geographic gaps, but we have, 40 contributors across these 26 chapters. And this is an ongoing project, by the way, and I'll talk a little bit more about some of the future work we're doing. But, we had different people kind of writing judgments in different parts of the world, looking in the Taiwanese context, looking at the Kenyan context, looking at the Australian context, looking at the US context, and kind of thinking about what queer might mean, how it's used, the way communities identify with particular terms or terminologies, and how, litigation or law might play a role in furthering the rights or the well-being of a particular community. And of course, if you're familiar with some of the queer work in law, you'll know that it has a real suspicion of the legal system. Because of course, the legal system, broadly defined, if you follow the kind of colonial trajectory of the common law, has been the source of enormous violence. right, to various communities around the world. And if we think about the kind of prohibition on homosexuality or gross indecency offences that they came to be known in the 19th century, a lot of the colonial nations, drafted those based on various formulations of the British legislation. Carnal intercourse against the order of nature, gross indecency. They use kind of slightly varying terminologies, but essentially kind of crystallize on policing gender and sexuality in very particular kinds of ways. And if you look to the history of law reform as well around decriminalization, for example, of homosexuality, there's been a lot of debate around the value of certain kinds of arguments. For example, visibility, privacy, dignity, the ways in which certain kinds of sexual practices, for example, become sanitized or domesticated in order to become palatable to a judge or a legislator, in order for legal recognition to take place. And so when we think about some of that background, people might ask, well, if you've got a legal system that is, been known for this kind of violence and perpetuation of stereotyping and inequality, then why are you looking to it in order to kind of ameliorate your situation or remedy or repair some of the things that you've experienced? Which is a really good question, and it's kind of the central tension of queer legal theory, is sort of how do we engage both politically in this kind of exercise where we both recognize the violence of the state or the violence of institutions, but also reckon that we can use law tactically in ways to alleviate someone's indefinite detention, for example, or grant of asylum, or to leverage them out of custody. How can we use law in those particular kinds of ways that prove fruitful and valuable. And it's also kind of a methodological question to bring queer and law together conceptually. Because if you think of queer as the kind of anti-normative, then law would seem the antithesis of that, because it's all about norms and rules and regulation. But of course, we also know queer has its own kind of normative commitments in some ways, in the ways in which it articulates certain ideas about the body or sexuality or community or sociality. So what we wanted to do is bring these two ideas, queer and law, together in their tension, in their kind of, ambivalence, in their hostility perhaps, or in their conflict with one another, to see how we might rewrite judgments that could speak to or honor, to some extent, the voices of people who had, been abstracted within these sorts of legal debates, but also to recognize the limitations of law at the same time as well. And so this has been the kind of ongoing, this is something I've always been really interested in, actually. This is where both the gender studies training and the law training together here at Sydney was really helpful, because I always got to think through these different ways of addressing issues and kind of thinking about how you navigate between more kind of liberationist, potentially, or radical kind of aspirations, and also how you work within more constrained institutional environments in order to affect certain kinds of change. And it's an ongoing thing, there's no right or wrong answer, of course. You're always kind of navigating that. And so we arrived at Queer Judgments with a few inspirations in mind. So I want to kind of acknowledge the work of some fantastic people who have kind of set the kind of intellectual space for us to be working in. One of the people